Good afternoon, everybody. Happy Sunday. Happy New Year. First Sunday of the new year, 2026. And we are going to have a spectacular show. And the reason why I say that is not have anything to do with me. It has to do with our guest, obviously, and most of you probably know her already. I got to say, I've been doing this for about 2 years, a little over 2 years, 2.5 years maybe. And it's very interesting to get to meet some other creators, other people, other lawyers. And, being here for about 2 years on this space and YouTube, and I did speak and interact with a number of different attorneys. I got to say that my interaction with Andrea, every time I speak to her, every time I see her posts, this is obviously a very, very intelligent, highly intelligent lawyer. And I know people have asked me, like, if you had to co-counsel with any of the lawyers that you've met on YouTube, who would be your first choice? I've got to say, I think my first choice would be Andrea. She is just sharp as a whit. And of course, she's got personality. So, anytime you try a case, both of those things are very important. So, very, very excited that she was graciously willing to come back onto the show to discuss this very, very important case. Before we do, I'd want to make one quick mention, and that is that if some of you may have noticed that we did reach our goal in this very special charity that we were raising money for. And I just want to give everybody a great thank you. You're not going to be hearing much more about it from me this year, hopefully. So we reached our goal, and that's just kudos to everybody out there. A big thank you to everyone who was graciously donated to this very, very special organization. It's an organization that helps families fight against cancer, give them the support that they need and all that. So I just wanted to express my gratitude and thanks to all of you that helped out in that regard. Okay, so without any further ado, let's bring Andrea onto the stage. And let me thank you again, Andrea, for joining us for our second meeting on the world of YouTube.
My pleasure. Thanks for having me back.
Okay, great. So before we jump into Richard Allen, which I know that's really the focus of this, I really want to get educated. I know that you're the person to get educated by. So before we start that cross-examination, I'm going to be asking you questions about. I want to first ask you two other unrelated to Richard Allen questions. I know that you watched Karen Reed, right?
Mm-hmm. Oh, yes.
You watched, and you probably had a number of interactions with people, ordinary people that are more educated about the case, less educated about the case. You probably have interactions with lawyers as well on this case. Have you?
Mm-hmm. Absolutely.
Have you, and I'm just asking this as a just an open-ended question. Have you met the lawyer out there yet who has said that in his opinion, Karen Reed should have been convicted based on the evidence that was presented in trial?
Nobody that is confirmed as a lawyer, who's not an anon claiming to be a lawyer.
Oh, okay. So that I've had the same experience actually. And I'm still, I asked this question to a lot of lawyers because, I showed them the picture of the arm. Obviously some of them are more knowledgeable about the evidence, some are less knowledgeable. We discussed the case, and I'm still waiting for that lawyer. And if you do find that lawyer, I'd love to have a conversation with them. And I've offered my show as a platform. Let's just have a conversation. It'll be a great exposure for your law firm. Show us that, show me that I'm wrong or whatever it is. And let's have a lawyer to lawyer conversation. I just think it'll be an interesting conversation to have. And we're still waiting for someone to take me up. I actually just sent an email today to another lawyer who I've heard maybe believes that. So I said, hey, let's get on the show and we'll see if they take me up in the offer.
Well, that'll be fascinating to see if you get a taker on that. I'll tell you, Martin, one of the kind of common themes that routinely comes up in LawTube is that, lawyers, we tend to think alike. Doesn't mean we always have the same opinions or anything like that, but it's just you're taught a certain way of looking at things and thinking about things through the process of going to law school, and it's kind of unique. It kind of distinguishes you from lay kind of interpretations of stuff. So, lawyers have a way of looking at things to understand, here's issues with the evidence. Here's ways that you can use it, procedures that are available and stuff like that. You have like this matrix of utility that you can fit that information within. And so it's very common that when a whole bunch of lawyers are watching the same trial, they tend to form a lot of the same impressions about it. There aren't that many where you have, lawyers that are wildly divergent. And when you do, it tends to be on some fairly technical questions. Like an example might be the Murdoch case, where I'm not sure there was really a whole lot of factual dispute among people about whether he was involved in the situation. It just was specifically, what can be proven and what does that establish in terms of like what specific crime would he best be convicted of. And so you hear a lot of noise, about from people who don't agree with your perspective, of course, and that's fine. People can have different opinions. It's just that often that tends to devolve into ad hominem and not very substantive or helpful types of critiques. And the common one, of course, is the grifter. You get the grifter accusation. All these lawyers are just grifting off the case. They're making all this money, and it's like, there's such a basic failure of just core economic understanding to not appreciate that, like, if there is a shortage of one position and there were a market to hear that, somebody would absolutely kill it, by stepping up to service that particular audience. And so the fact that doesn't happen should really kind of say a lot about the merits of the opinions that the lawyer folks are putting out there. So I offer that to you as a kind of part of my experience, going all the way back to Depp versus Heard and the types of critiques that we heard about that. It just comes with the territory.
Yeah, what's interesting is that I thought, and again, I remember I started this about 2 years ago, and I obviously my Karen Reed was not my first case, but the first time I heard the term grifter was with Karen Reed. And I was like, it seemed to me like this is a term that's associated with specifically the Karen Reed case. And then as I'm, getting more involved in the world of social media, I realized that no, everyone from anyone who's ever posted any sort of thought on social media could be called a grifter. It doesn't matter what it has to do with anything, So I'm like, oh, okay, this is just, a regular attack that everyone uses against somebody who's taking a position in anything for any reason. So it's something I'm learning as I'm not as well versed in all this stuff as you are. But
well, what's kind of surprised me the most about my time in LawTube and just shooting off my mouth on the internet is the extent of the information management that is really out there. It's something that I really wasn't aware of until I started talking about cases, and I started getting these types of responses and these very hostile, like I said, ad hominem types of reactions. A lot of just conclusory insistence that you're wrong, I'm right, this is what happened, and of course not a lot of nuance. And I'm sure some of that in here is just an internet conversation entirely. But I do always, at this point, start to wonder now about the extent to which that is deliberate, that there is a particular goal of trying to squelch, people's natural curiosity about cases, people's natural interest in cases, people's ability to look at information and form their own opinions from it. And this is a great segue to the Richard Allen case, because if there is one case that is just, it's really one of its defining characteristics is the distinction you see between who wants the information out there and who is still to this day hiding information, a lot of it illegally, not in accord with the laws of Indiana for access to public records, court records, and things like that. And it really makes me wonder when I see that type of thing happen. What is it that you're trying to protect? What is so scary about people being able to form their own opinions from the evidence?
Yeah, exactly. So I'm not going to allow you yet to segue into Richard Allen, because I had one more topic I wanted to get with you before we get into that. But then once we get past the second topic, it's all going to be Richard Allen. So in case anyone's come to Richard Allen, we are getting there, and we are going to do a deep dive as much as I can. But before we get there, one other question that I have for you, and I didn't see that you covered this case really, is called the criminal defendant is called Kelsey Fitzsimmons. Have you heard of that name before?
Yeah, so I've heard of this case, but it isn't one that I have followed particularly closely. I was aware of the issue with her release being revoked for apparently not good factual grounds, but it got appealed all the way up and was denied, and then they went back and she got released. I saw the kind of process of that unfold.
Right. So I was just going to, and this is a question that I ask a lot of lawyers, definitely ones that practice in criminal defense or prosecution, which I think you've done, right? So
yeah, I've been criminal defense for my pretty much entire legal career.
Okay, so you're the perfect person to ask this question to. So the question goes like this: you got somebody who's out on bond. Okay, you got your client. Your client's out on bond now. There's certain restrictions, and they did not violate any of the restrictions at all. They didn't violate anything. And in fact, the probation officer at this hearing said that he would not consider anything that she did to be a violation. And nevertheless, for whatever reason, have you ever experienced a situation where the judge will revoke the bond regardless whether there's been a violation?
No. I mean, this is like fundamental due process that it's not that like you have a vested right, so to speak, in your release or anything like that. But if there are conditions that have been set, then there's a burden of proof that has to be met, that there's some type of change in circumstances that means that those conditions are no longer adequate to be able to, protect the community, ensure that you're going to show up for court or things like that. And so the most common change of circumstances is, well, this person violated. It's not the only way, but it's by far the most common way. And so a situation where there's been no change of circumstances, except that you have exercised your right to bring a motion in court. That's the part that to me was a little bit alarming about the Kelsey Fitzsimmons situation. That it seemed that it was fine. Like, yes, she was having difficulty performing the test, but she was able to do it on I think a couple of occasions when she wasn't able to complete the test. The probation officer explained like it wasn't we didn't treat it as a non-compliance type of issue. So that to me, yes, was pretty unprecedented and alarming. And I think what ultimately happened, just from kind of my take on it, which wasn't really that in depth, but I did read some of the orders and things like that, was this is just the type of judge who knows how to insulate that order, who knows how to write it in the way that will craft things in the way that's going to be most acceptable to a reviewing court. Making sure things are about credibility, making sure that there's just enough factual findings to kind of be able to substantiate the conclusions that are brought. So unfortunate situation, but you spend enough time in criminal defense and you do get a little bit black-pilled on what judges can and will do when they have a defendant in front of them that they don't want to give any advantages to.
Yeah, but I always find it interesting because I always like to ask that question. Have you ever had this type of situation ever happen where you have somebody that didn't violate the bond, excuse me, and their bond was revoked? And everyone so far has answered to me that they've never had that happen. And they've all, excuse me, they've all cited due process, especially in this case when the motion was to modify the bond. And then sua sponte, the judge just said, you know what, I don't think you can do it anymore, so just go back to prison. Yes, so that reeked to me of due process violation. And I'm actually very surprised, if I can say myself, I'm very surprised that the Supreme Court was even more surprised. They didn't even analyze the due process argument. I mean, that's so shocking because the argument was made in their papers, in the appeal papers, in the brief. They wrote a whole opinion addressing almost every single argument. And then for whatever reason, maybe to protect the judge, they decided not to address the due process because it reeks of due process. But let's move on to Richard Allen now. And I just wanted to take one comment because this is from my brother, Solomon Radner. It says, great show. You two are excellent together. Nice jersey. Martin, has Fred seen it yet? Fred is the person who won my other jersey. So we auctioned that off to benefit this charity. Okay. Now let's talk about Richard Allen. And I'll tell you what I know just preliminary before we get into more of the details and more what you know, which is obviously a lot more than I know. By the way, what's this one's name?
This is Joan right here. This is little Joan of Arc.
Joan of Arc, okay. What are the other six?
So they got a new toy for Christmas and they're completely obsessed with it. So I have it going. It's like one of these interactive toys where they can, chase a thing around. And so I set it up for them downstairs, and normally that means that they will then ignore me for like 5-6 hours. But Joan maybe got excluded. I'm not sure.
Yeah. Well, amazing work you're doing there with the kittens. So let me tell you where I got a little bit involved in the Richard Allen case. I did like 2 videos about it is a long time ago. I actually went and tried to rewatch some of them. And you know what it's like watching your old videos. Like it's the last thing that you want to do. But I had to do it. And I was going to even like play a segment for it for us, but it's just too embarrassing. So you guys want to watch that, you have to go back a year and a half to find that video. But anyway, so this is what I understood from what happened. And then you can maybe fill in some more details. You had a situation where there was a gag order on this case. And somebody, and again, the 2 attorneys that I knew on the case was Baldwin and Rozzi, right?
Yes.
They were representing Richard Allen, and there was some sort of leak to the press. Now, it seems like maybe the prosecution leaked first, and then the defense kind of in response, leaked their own, defense or some of the defenses. And then there was some guy who used to work at, I think it was Baldwin's firm or Rozzi's firm, who just kind of pranced into the office one day to say hello to everybody. And that happens, by the way. You'll have an old employee or an old lawyer that will drop by and say, hey, how everyone's doing? You go, talk a little bit. And it seems like they wandered into the war room, saw some of the pictures that were of the crime scene or whatnot, took their own pictures of those pictures, and then disseminated them, right?
Yes.
And that's what caused a lot of this outrage. And to use a term that we've heard from the Karen Reed case, the judge said that she has grave concerns about these 2 lawyers representing Richard Allen now because, number one, the leak, and number 2, these pictures going around that it showed gross negligence. And in fact, again, this is from everything that I remember, is that even when they offered to represent Richard Allen pro bono, they were still not allowed to do that. Now, just to throw some more context, and again, you can fill in all the gaps here, but from what I remember is that there was some sort of in-camera meeting in the chambers, in judges' chambers, and that day, for whatever reason, the judge opened up the court to the cameras and the videos, so the entire press there for one of the few hearings that was going to be publicized, and you can talk more about that also, and the judge basically in chambers said, look, this is what I'm going to do. I'm going to read how you're incompetent and I'm throwing you off the case, and you're going to get your dose of public humiliation, or alternatively, this is like an offer you can't refuse, or you can just duck out respectfully and I won't have to publicly humiliate you in front of everybody. So they said, okay, we're going to duck out, respectfully. And that seems to be what happened. Then what happened was, I guess they had second doubts about this, and they went and filed a writ of mandamus with the Supreme Court. And then at the Supreme Court level, not only did they say this is not fair, this is not due process or anything like that, but also this judge needs to be disqualified. And now this is very early on. I think I did this video maybe in 2023, and maybe 2022. I don't know, maybe 2023. That makes more sense. And the decision came down from the Supreme Court that they're going to allow the attorneys to stay on the case, and they're not disqualifying the judge. So at the time, I said, wow, I would love to be in that courtroom, because there is going to be tension that you can cut, because between the judge and these attorneys, I mean, there is going to be some fireworks or whatever else that we can expect to see. And that was the end of it. And that was the end of my analysis. And then I guess I got busy with the Karen Reed and other stuff. So why don't you kind of help me out more with that story, and then say how this may have led to other things, and tell me about the relationship between the lawyer and the judges as the trial continued.
Yeah. So, I mean, this is one of those issues, the interference with the right to counsel. This was a very pervasive one throughout the case. It was manifested in this particular incident that you're referring to. It manifested in things like they were unable to meet with him because he was detained pre-trial in a maximum security prison in solitary confinement. So they would have to meet with him in prison. They were unable to do so confidentially. They would have their meetings video recorded by prison staff and things like that. Significant impairments to their ability to do the job of defending their client. And so I would fill in your story, I think, a little bit by going back further, because this was not a problem that just started with the quote unquote leaks. And yes, I think you've highlighted there are some significant questions about the source of the quote unquote leaks. There is plenty of reason to believe that some of these leaks involved the prosecution or the investigators, individuals who were associated with the state. And that has to do with like markings on some of the items that were obtained by typically content creators. But there was this incident where the gentleman that you're referring to, Mitch Westerman, he was a former employee of Andrew Baldwin's, had gotten access in the conference room to the discovery materials, took the pictures and so forth. And so that was what triggered this process of getting Baldwin and Rosie removed. That ambush hearing, as Mr. Rosie refers to it, where the judge ambushed them in chambers. Basically, it was the one time that she allowed cameras in the courtroom, was that particular hearing, where she announced her intention was to publicly humiliate them, berate them, if they did not voluntarily agree to step off the case. But the reason why I want to step back is because this problem, it didn't just start then. This emerged at the very beginning of the case, from the point that Baldwin and Rosie were appointed. And the reason why is because, of course, as soon as they were appointed, they began to investigate the case. And on December 1st of 2022, they issued a press release. Now, of course, the case had been out in the media for 5 years. It took 5 years for them to find a suspect to arrest and press charges against. There were a lot of efforts to cultivate public interest over that 5-year period because they were dependent on tips. And so there were interviews given by law enforcement, by family. There was encouragement to go out and keep talking about the case, keep it in the public eye, so that we can continue to get tips about it. And then as soon as Mr. Allen is arrested and charged, the mood and the attitude towards the public interest, it just shifts on a dime. From this is a helpful way to potentially be able to get information, to characterizing the public as bloodthirsty.
Oh, yes, I saw that.
I showed you the safekeeping order, which is just one of the most bizarre pieces of legal writing I've ever seen in my life. It reads like the kind of crazy letter that you get from a pro se defendant who has, who's in jail and has a record this long. It does not read like ordinary legal writing.
You mean like Sarah Boone? Is that what you mean?
Yeah. Yes, that's a pretty good example, actually. And so as soon as, of course, there'd been all of this press for years. And then as soon as Mr. Allen is arrested and charged, there is a press release or a press conference that's held by the prosecuting attorney, and the investigators are present and so forth. So they, as is kind of typical, get to have their say about, we've got the guy and finally it's over, and, all the things that are kind of implying his guilt. And as is often the case, the defense doesn't get to respond right away. So there's like some background with that too, because they sealed the probable cause affidavit for like a month. It was just this very crazy stuff. But anyway, what ultimately happened was that on December 10th, the defense issued a press release. And in this press release, they specifically responded to some of the claims that had been made at the prosecutors, in the probable cause affidavit, in the prosecutor's press release, and so forth. And so they pointed out, Rick is a 50-year-old man who has never been arrested or accused of any crime in his entire life. He's innocent and completely confused as to why he's been charged with these crimes. Police did not contact Rick after the girls went missing. Rather, Rick contacted the police and voluntarily discussed being on the trail that day. He wanted to help, like many people in Delphi. Without him coming forward, they probably would have never known that he was on the trail at all. He volunteered to meet with a conservation officer to give details of his trip to the trail on the day in question. He tried to assist. He provided information. His contact was brief. After he shared that information, he went back to his job at the local CVS in Delphi, across the street from the sheriff's office, and just lived a normal life for 5 years. The next time Rick heard from the police was in October 2022, approximately 2 weeks before a contested sheriff's election and within days of a federal lawsuit filed against the Carroll County Sheriff's Office by its former second in command, Michael Thomas. In that lawsuit, he claimed he'd made suggestions and offered assistance about the investigation, but there was disagreement from the elected about that. He claims that he was ultimately demoted and replaced by Tony Liggett, Sheriff Liggett, who later won the election. He was also removed from any involvement in these high-profile cases. Rick was ultimately arrested at the end of October. In the 5+ years since he volunteered to provide information to the police, he did not get rid of his vehicle or his guns, didn't throw out his clothing, didn't alter his appearance, didn't relocate himself to another community. He did what any innocent man would do and continued with his normal routine.
Wow. I mean, you're saying a ton of information, but each one's hitting me like a ton of bricks. So first of all, he voluntarily came to the police.
Yes.
He was being helpful for 5 years voluntarily.
Yes.
Didn't get rid of his guns, didn't try to run, didn't book one-way tickets to Vietnam. I mean, he is cooperating and trying to be helpful to the police. Voluntarily gave the information that he was on the trail. And then how did the police end up identifying him as a suspect?
So the official story from police is that they had this original tip from when Richard Allen had called in, and he was interviewed by this conservation officer, Dan Doolin, provided information. He gave his cell phone identification number, and went about his day. They marked his tip as cleared. And then, according to the state, they lost it. They misfiled it. It had been originally entered under an incorrect last name. They had confused his address, which was on Whiteman Drive, with his last name. So it was entered into their system as Richard Allen Whiteman instead of Richard Allen. Now, exactly how this poses a huge problem to them, being able to find tips is not entirely all that clear to me. But their story is that the paper version of this tip before it was entered into the electronic system, it had been lost. It had been misplaced. It was somewhere in the bottom of some file drawer that was maintained by a volunteer, a former CPS officer who used to kind of assist with this part of the investigation. And she just happened to find this tip in, I think, September of 2022, 5 years later, and decides, or 2022, decides that, even though it's marked cleared, that it's something they should revisit. It's something suspicious. And so they do. And it's all basically built on this tip from 2022 that they refined in 2022. And so what happens is then they go and they interview Richard Allen.
What's the tip?
I should say interrogate him, because they read technique him.
What is the tip? Like, what's the tip? What does it say?
The tip is Richard Allen himself called in to say he was on the trail that day.
Oh,
and so yeah. And this was,
you're saying it was somebody else who called in this tip.
No, I mean, that's the thing. And so,
so they lose this tip because it's entered into the wrong database in the wrong name. Eventually, they find they circle back and get it, and now they interrogate or interview, whatever you call that. I mean, did you see what it looked like? And I guess maybe in court you did. Okay,
yeah,
so then tell us what that interview looked like, because I don't think the rest of us were able to see it, right?
No, those are public now. And so
Okay.
I have shared with you, over on Twitter, but one of the absolute best resources out there for this case is All Eyes on Delphi, has the GitHub site. And it is comprehensive. It has evidence, it has filings, it has timelines, it has just all kinds of ways to access and review the what evidence we have been able to get in this case. So it's by far the most comprehensive. But yes, so
this is also evidence that was presented in court, which the cameras were not allowed.
Yeah. So what they have been able to get what the court has allowed us to see in terms of the evidence that was admitted in support of various pretrial motions as well as at trial. That is available. All Eyes has that. Now, that is limited because the court has decided that certain information, certain evidence, certain exhibits, we, the public, are not going to be allowed to see them. And that decision was made it's not in compliance with Indiana law, with their procedures for being able to seal off this type of information. So that's part of what I mean about, there's some legal issues. Even if it complied with Indiana law, you have this vast sphere of First Amendment law and kind of common law right of judicial access to court records that make it pretty clear. Court exhibits admitted in open court, things that are part of the adjudicative process, that the public has a right to be able to see those.
Yeah, this sounds like we need a Corey Hopkins lawsuit on this. Are you familiar with her?
Oh yes, very much.
Yeah,
very much.
So sounds like we need a little Corey Hopkins work on this. But anyway, okay, so you did see this interrogation or this interview, whatever you want to call it. And
yes.
This
so
is
I've seen it.
Time.
And it is out there. You can see it on the All Eyes as well. They are video recorded. There's transcripts of them, so you can see them in different formats.
Okay, so let me hear. So what happens at the interview?
Mr. Allen, from my perspective, presents about as innocent as you expect somebody to do. He just, he's denying involvement. What happens is that in the initial interview, he's clearly already under suspicion. And so, he starts to catch on that, it seems like you guys are maybe trying to pin something on me. They're asking for his phone to be able to extract his phone. They're asking to be able to go to his house and look through his house. And he's like, wait a minute, I think I'm not going to do that. So the interview basically goes downhill very quickly.
By the way, stop for a second. Stop because this person says Andrea did that.
So I did this during
Andrea did that.
during the trial. There were two things that I filed to the Indiana Supreme Court about. There were audio recordings of the trial that were taking place at the time that the trial was happening. I argued for those to be released to the public, in part to alleviate some of the just nightmare that trying to get into court became with the limited seating and the fact that there was no other way to see for yourself, what was going on in that trial. The other thing that I tried to do was during the trial, the exhibits would be admitted into evidence. Sometimes, of course, they would be published, but sometimes they would not, or they would be published just to the jury and not to the audience. And so what happened was that Judge Gohl entered an order that said at the end of the day, she would make the exhibits available to the media, to people with press credentials to be able to come in and inspect them. And she then denied that access to those of us that didn't meet the criteria to constitute press under Indiana law. And Indiana law defines press in one of those ways. It's basically based on, do you have a relationship with somebody that we have approved of? A wire service.
It's not about how many people are watching you or listening to you, Andrea.
Absolutely not about your audience or even the quality of what you're presenting. It's just based on, do you have a relationship with somebody who is one of our old boys.
Right. But then did they publish all these exhibits by themselves? All this, this mainstream media?
No, so they couldn't get copies of them, but they were just able to come in and see what they were. And so for a lot of things that were like photographic evidence and stuff like that, the media was the only people besides the jury that got to see that. And so that was part of what my original action was also about, was to say, look, there's all kinds of case law that says the media doesn't get any special right of access to court proceedings above and beyond the public. They are the same as the public in this context. There is no basis for discriminating between us and depriving the public of our right to be able to see these things as well. And what ultimately happened was that, so two things. One, they just waited until the trial was over to address my my original action. So by then, the viewing the exhibits, it was moot. They just let that moot itself out.
It can't be like an emergency hearing on that,
Yeah, no, nothing real urgent to deal with that. But then the other thing that I found out was that so my request for the audio recordings had been based on the rules, which the rules for trial procedure, which unbeknownst to me and came as a surprise because the prior rules were still published on their on their government websites was they had amended the rules at the beginning of the year, and they had completely changed the rules to be able to get access to recordings of court proceedings. Previously, anybody could get them. They changed the rules at the beginning of that year to now nobody can get them, and sometimes even trial counsel can't get them. Ultimately, my writ on that one on public access didn't go anywhere. They didn't offer any reason. They just denied it without any further comment.
Okay, but that was a separate action that you filed just so that you can have access, the same access as the media does, let's say after the day of trial. But this is not a separate action which you would file now for them to release all the exhibits now that the trial is over.
Correct. Yeah, very different process. And so I will say I have kind of looked into it. I have, thought about maybe pushing that a little bit further. I was waiting to see initially, because now we're in a different forum. We're on appeal. And so all of this stuff has been transmitted up to a court of appeal. We have now a different potential venue to be able to go to ask them, maybe look at this differently than we already know what Judge Gohl is going to say, because we have a long record of Judge Gohl just sort of doing what she wants without ever offering any real rationale for it. So I was kind of waiting to see, okay, what are we actually going to get access to through the appellate process? Is there going to be any kind of effort made to reconcile, what they have that's been provided to them confidentially versus what they have that provides a basis for them to have, confidentiality assigned to any of these records and so forth. So I have been looking at that.
Okay, so let's go back to the interview. So there's this interview, they call him and he thinks, okay, this is the same me, been helping you and being open and honest with you about this, the past 5 years. So now let's talk, I guess, formally. So now in the interview, he starts to realize, hey, you guys sounds like you're suspecting me. So then what happens then?
Yeah, well, so first off, during the interview, they're just revisiting, they start off by revisiting what happened that day at the trail. When were you there? How did you get there? What were you wearing? Things like this. And so Richard Allen is open and provides answers to all of these questions. Once things start to kind of turn to where, he's realizing you guys are trying to pin this on me, I'm not going to cooperate anymore. He terminates the interview and he leaves. And so the next step is that the investigators go and get a search warrant for his house. And to get the search warrant in the house, they have to misrepresent what he said during this interview. So this is actually one of the grounds that has been raised on appeal for potential reversal, that he should have had a Franks hearing on these allegations, because the detectives claim that he attested to a certain route that he drove to get there. He did not. They attested that he claimed to have parked in a certain location. He did not. They attested that he claimed to be wearing the same clothing as Bridge Guy. Are you familiar with Bridge Guy?
No, I'm not. No, I'm not.
Okay, so I'll fill you in on Bridge Guy. So for years, there were only like little bits of evidence that were publicly available to kind of help the public identify who the potential perpetrator might have been. There were some sketches by witnesses who had been on the trail that day that were released. And then there was also this screenshot from a video. This video was taken from Liberty German's phone from when they were out on the bridge, on the Monon High Bridge Trail, the day that they were killed. And so the video, which I could get into issues with the video too, but it gets long and complicated. But anyway, the video at one point shows Abby walking on the bridge, and behind Abby there is a man who becomes visible. And so they screenshotted that man and kind of blew him up and released this photo pretty early on in the investigation as their prime suspect. And so this is Bridge Guy. That's Bridge Guy. Now, bear in mind, Richard Allen, like we said, he went back to his job at the CVS in Delphi, a customer-facing job. He works at the pharmacy counter in Delphi. And over that 5 years, not a single person, they received tens of thousands of tips, probably 20,000 tips or something like that. All kinds of people calling in. I think my old boss is Bridge Guy. I think my brother-in-law looks a lot like Bridge Guy.
Nobody said that the CVS guy.
Not a single person ever said, hey, that guy who works at the pharmacy counter at CVS, he kind of looks like Bridge Guy. So anyway.
Okay, so coming back, so this police officers,
yes.
in order to get this search warrant for his house, they had to lie on this search warrant. That's basically
they had to lie on the search warrant about the things that Mr. Allen said during this interview.
Right. So because
of that,
tree, right?
They put him in the same clothing as Bridge Guy. They put him, parked in a place where witnesses had seen a suspicious car, which incidentally, as they described it, looked nothing at all like Richard Allen's car. They left that part out. And so based on this, what they asked permission for was that at the crime scene, when the girls were found, kind of between the bodies and partially buried in the ground, they found an unspent shell cartridge, a 40 caliber cartridge. And it had been cycled through a gun, but it had not been fired. So it had markings on it from the ejector, extractor, and things like that. Actually had been cycled through multiple times from the gun. So they asked for permission to look for, clothing that would look like Bridge Guy's, but their real focus was on finding a 40 caliber firearm and any, ammunition and things like that might allow them to track it to Mr. Allen. So they get their search warrant. They go and they search his house, and he does in fact have a 40 caliber handgun. It's not particularly uncommon, as we found. Trial, there were several individuals whose handguns had already been recovered and compared to this bullet that was found at the crime scene, and they were not able to be excluded from being the gun that left the extraction marks and so forth on this bullet. However, as soon as they found Richard Allen's gun and submitted it to the tool mark analyst, she was now able to say definitively, "Oh, this absolutely came from Richard Allen's gun." And the way that she did that was that she first cycled some 40 caliber cartridges through Richard Allen's gun and could not find any marks that she would be able to compare to the cycled marks on the bullet found at the crime scene.
So then
what she did is she put bullets into Richard Allen's gun and she fired them. And then she compared the marks that she got on the fired spent shell casings to the unfired gun that was found at the crime scene, unfired bullet that was found at the crime scene, and concluded they match. And
they're different things. I mean, they're different things. How can?
Indeed, they are. Yes, indeed, they are. Yes, I'm glad that you noticed that.
So then,
completely different things. I mean, I have to laugh because it's so dark. If you look at this seriously and what they actually did to build the case against this guy, the absurdity of it is just through the roof. That was the best piece of evidence they had against Richard Allen, was this bullet where they compared the apples to the orange, and concluded it's a match after they had previously said all these other guns we can't rule out, but now that we have Richard Allen's gun, we can. And that
can I ask you a question? Did they did this expert, quote unquote, firearms expert, did she also fire from these other suspects guns who had 40 calibers that she was not able to rule out before and then compare the spent round of a fired one versus it? No. Wouldn't that have been a good exercise to go to do?
I mean, none of it's a good exercise.
None of it is. But if this is what you're going to be using, then shouldn't you also do the same with the other suspects and see, oh, it's different when it fires from these guns as opposed to this one?
I suppose that would slightly improve the process. It's still going to have some fundamental problems with the predicates behind it. But no, and so in fact, there were big problems with just the basic scientific validity of what it is that she did. Richard Allen had a proffered expert, a metallurgist, a PhD, who is highly critical of tool mark evidence in general for a lot of reasons. This is something that I myself have litigated, many years ago. It's not a particularly strong science. It's extremely subjective. The standard to be able to find a quote unquote match is basically self-referential. It says the analyst gets to can determine identity when there is quote unquote sufficient agreement between the item that she's looking at and the item that she's comparing it to, and nowhere is sufficient agreement to find. It's just whatever the analyst decides is what meets the standard. So
let me ask you this: so was there a Daubert hearing for that expert?
Oh no. Okay.
Was there a request for one?
I don't believe there was a request for him, but so what they did, there may have been. I have to remember back now. So what the defense had really tried to do was to just bring in their own expert, this PhD guy who's been a critic of this methodology, and allow him to testify about the problems with it. And so he was excluded. They didn't get to present.
Why? Was there a Daubert challenge
of any of that?
Why was there a Daubert challenge for him? Well, why was he excluded?
No, it was a motion in limine to exclude him, and as I recall, her rationale was that he wasn't relevant. He didn't have the right expertise because he wasn't a metallurgist. He's a metallurgist. He wasn't a certified tool mark examiner. A qualified tool mark examiner. And so she concluded that because he wasn't a tool mark examiner and because he hadn't looked at the analysis, the evidence that the state's analyst had produced, that he was not going to be allowed to testify at trial. Well, she was wrong about that. He had in fact looked at the analyst's work and had critiqued it. And he does have expertise in the methodology and the standards and so forth, because he's been a witness about that thing, as an expert almost 300 times in other courts. But this was, just kind of par for the course of the cavalier attitude that Judge Gohl took towards Richard Allen being able to present anything that might suggest that he was not the perpetrator of this crime.
Let me ask you this. So was there any DNA evidence?
So there was a lot of DNA evidence. There was DNA from females. There was DNA from males. There was DNA on the clothing. There was DNA on the bodies. There was DNA on I believe on the phone. There was a lot of DNA, and none of it was apparently found to be suitable for comparison. And the explanation that the state's witnesses, their forensic analysts, gave for the presence of all of this DNA was that it was just probably all background information. For example, there was male DNA found in the underwear. And in fact, actually, I hate to say this, but in the bodies, there was some evidence of seminal fluid. Presumptive test, they didn't confirm it, but just kind of an issue. And then male DNA in the underwear. Their explanation as well.
They couldn't get a profile on that and the DNA.
So no, they said it wasn't suitable for comparison. It wasn't a sufficient quantity or quality for them to be able to draw conclusions from it. Now, I can argue with this from a technical standpoint because often DNA evidence that isn't adequate to be able to include suspects, you don't have a strong enough correlation. You don't have the ability to exclude enough people to be able to draw meaningful conclusions if all you have are, say, one or 2 points on the genome to be able to compare, because a lot of people are going to share that. Most STR DNA analysis, they're looking at 20 or more points on the genome. And so when you have like 20 things that line up, you have a lot stronger statistical inferences that you can draw from that than just 1 or 2. But that said, even if you've only got 1 or 2, it's typically enough to be able to exclude people. Like you can compare it for exclusion purposes. But there's no indication that they did that with Richard Allen. And their explanation was that these girls lived in places, in homes with males. And so it would be perfectly normal to expect environmental contamination. The laundry gets done and you would expect male DNA, from their households to end up on their clothes. It is the only case I think.
Wait, stop for a second. Stop. I want to explore that a little bit.
Yes.
So these girls, they lived at home with like brothers and their father and like that type?
Uncle, father, grandfather. Yes.
And therefore, they're saying that the DNA on the laundry, which they can't, is not enough for comparison to be able to include the father or the uncle, but that's most likely where it's from. What about the fluid inside of them?
So they didn't explain that. This was so what they did is they had vaginal cervical swabs from both of the girls from the autopsy. They ran a presumptive test for the presence of semen on those tests, and both of them came up positive. So their testimony was that at that point, they have two things that they can do. One is that they can either confirm, they can run a confirmatory test for the presence of semen, or they can test it for DNA. And either one of those, according to them, would be consumptive. So they chose to do the test for DNA, and they were not able to recover any male DNA. So never confirmed officially one way or the other whether those presumptive positive tests were actually semen. Now, here's the issue: these presumptive tests, they have, of course, a failure rate.
Let me just ask you a question. What other liquid from a male would it be in there? I'm educate
well,
me.
So here's the thing: it doesn't necessarily have to be liquid from a male. Depending on the kind of the test that they did, what they're testing for is a certain hormone. It's a prostate-specific androgen that they're looking for, and the reason why it can produce false positives sometimes is because women do produce this hormone sometimes, and so
does it make sense within their age? Does it make sense
produce it in these quantities? Well, it's usually associated with something like if you've got PCOS, if you've got a syndrome that's associated with production of androgens, and so it's about a 10% failure rate is what I've read for most of these tests. So a 1 in 10 chance of getting it wrong for one person wouldn't really be that shocking, but of course a 1 in 10 chance of getting it wrong for both of them, that's starting to get more implausible. Now we have a 1% failure rate, right, or a 1% chance that presumptive positive was incorrect as to both of them. So this was never really fleshed out during the trial, but it just is one of those background facts that kind of, to me anyway, remains lurking out there about these presumptive tests.
So just to be clear, there was no DNA from Richard Allen that they were able to. Okay, at the scene. Okay, so there's no DNA.
No DNA.
Okay, so there's no DNA.
Yes.
Now, what about this confession that they talk about?
So the confessions, yes. So the bullet was the strongest evidence that they had against Richard Allen up until the point that they threw him into, as we talked about, the maximum security prison in the solitary detention wing, where he was held for 13 months pre-trial as somebody with no criminal history whatsoever. During that process, his condition deteriorated significantly. This was documented both in the psychiatric records and also in the observations of his lawyers when they finally got to see him, phone calls that he made with his family and so forth, and video records from inside the prison, of his cell and when he was moved and things like that. So he lost a substantial amount of weight. He began to basically, he got extremely distressed and ultimately became psychotic. And so he was treated involuntarily with Haldol while he was there in the prison, which is a very powerful first generation antipsychotic. And he remained psychotic by their own records for at least a month. If you go by just behaviors that are seen and stuff like that, it's more like at least two. And so during these psychotic episodes, he began to make statements. He began to claim that.
Stop. So wait, these statements were during that month period, or was it after?
Yes. No. Okay. During the period of when he became psychotic. And so he began to make claims that he had been involved in the murders. And so these confessions, they took a lot of different forms. Most of what we heard and most of what there is actual document, like objective documentation of are recorded phone calls that he made with his family. And so he, for example, made a phone call to his wife at some point in early April of 2023, where he says, "I think I did it. Maybe I did do it." He's, confessing in these types of terms.
And this is April was the month that he was psychotic?
Yes.
Okay.
Yes, April is the month that he, it's really towards the end of March, going into April is when he is psychotic at this point. And he's early on, he's kind of still, he's like kind of coming in and out of lucidity. So there's a point where this particular phone call that I'm talking about 3 hours before that, maybe 2 hours before that, he had called his father, and he had a conversation with his father where he said he feels like he's losing his mind, not sure that he can take it a lot longer, thinks that they are, putting stuff in his water. He's trying not to drink or eat the food because he thinks that they're poisoning him. Has this phone call with his wife where he says, I did it. I think I did it. Maybe I did it. And she's telling him this whole time, like, no, honey, you didn't do it. You just, you've lost your mind. And then a couple hours later, he calls her back and he's frantic because he doesn't remember the earlier phone call and doesn't remember what he said, doesn't remember if he said that he confessed or anything like that. So this is the context, right, of these confessions. Now, so that's most of what we can hear with our own ears from what was actually recorded, what can be objectively verified. But then there are other sources of statements that are attributed to Mr. Allen that cannot be verified like that. They come from primarily two places. One is that while he was in solitary confinement, they assigned what they call suicide companions, which are inmates that sit outside his cell, and they write down every single detail of what he's doing and what he says and things like that. And so several of these suicide companions, these fellow inmates, wrote down things that they claimed that he was saying that amounted to confessions. Now, a lot of these, it should be noted, were confessions to facts that were not correct. Things like he shot the girls. The girls had never been shot. He was making claims about things like he had abused his own daughter.
Wait, stop a second.
His daughter denied that.
Can I stop you for a minute?
Yes. How
did the girls die?
They had their throats cut. They died from exsanguination.
Okay, so all these spent bullets, what were they? What do they have to do with the crime?
Well, that's a great question because there is no actual proof that this bullet that they found, which is not spent, by the way, unspent. It was a single unspent shell, a cartridge, a full cartridge, partially buried in the ground in the vicinity of the crime scene. There's no evidence that it has anything to do with the crime whatsoever.
Okay, yeah, that I assume that they were shot. That's
there.
I assumed that they were shot. That's what up until this point.
Yeah.
And then all of a sudden you say, yeah, like another, I was like, well, okay, fine. Sorry. I'm sorry.
Yeah, no, great question. The state had a whole theory about how, the killer must have had a gun and that he would have racked a bullet to to intimidate them or something like that. That he used it to control them for fear purposes, and he just happened to eject the bullet and never noticed or something like that. But there's absolutely no proof of any of that. There is just a bullet that is there at the scene. Couple of things to know: the crime scene.
Wait, I'm sorry. Can you? I don't mean to cut you off. I don't mean to constantly cut you off, but I just want to get back to that thought that you were going through before. That some of his confessions were actually inaccurate. So, like you said, for example, that he shot her. Were there any other examples of his confessions that were inaccurate or incorrect?
I have to remember. I can't. Okay, so I can't remember specific. Yeah,
off the top of my head. I thought you were continuing with that. That's why I wanted to go back, and I don't want to lose that. But okay, so go ahead.
Yeah, so that was the main one that I remember, was just that he claimed that he shot them and he clearly hadn't, and so he had made other claims around the same time, like that he had abused his own daughter, which she has testified definitively, absolutely no, he did not. This is not true. But he was basically in this mind state where it started off with religious hypermania. He got like very fixated on the Bible. And it seemed to be associated with a lot of just sort of, guilt and kind of weird sexualization of things. He was like confessing to sins and he was doing things to himself. Okay, now this is very unpleasant stuff when he's in the psychotic state. He is eating feces. He is smearing it all over him. He is taking a spork and sticking it into his member. It's pretty horrifying what the man went through in the condition that he was in at the time that he's making these types of claims. So we have the claims to the suicide companions that are not verifiable in any way. Just the suicide. The other inmates say that he said these things. Then you have a second source of information, and that is Dr. Walla.
Okay,
so
before we get to Dr. Walla,
yes,
let's pause it for a minute. So this guy that was outside, this suicide companion, he also heard Richard Allen say that he murdered the kids, and with a gun.
Yeah, so there are suicide companions that claim that they also heard Richard Allen confess, that they wrote this down in their notes, the things that he said. And so yes, and some of those claims were things that were not accurate.
How many of the suicide companions?
Oh, I can't remember now off the top of my head. At least one, but I think more than that.
And did they all testify consistent with the same type of confession that he said?
So none of the suicide companions that were inmates testified at trial. What they did is that at a certain point in the process, the inmates were swapped out with prison guards. And so then prison guards came in and they performed the suicide companion role. And so several of these prison guards were called as witnesses at trial to testify about the types of things that they saw and heard and so forth. Now, I'm trying to remember off the top of my head if any of the prison guards actually heard him, quote unquote, confess. I think there might have been one or maybe two, but it wasn't overwhelming. By and large, the reason why the prison guards were brought in to testify is to testify that he was faking. In their opinion, he was faking his mental illness. He was doing all of these things to
There's no way that can come in as evidence. They're not experts in that.
Well, no, they are not experts in that whatsoever. And this is how I learned about Indiana's learned witness doctrine, which if you ever want to just tear your hair out in horror at
I'm doing it now
for evidence in an Indiana court, go look into the learned witness doctrine. And so basically what it is it's just a special rule that they have in Indiana where somebody who is clearly not an expert and has no expertise and wouldn't meet the qualifications to be an expert, nevertheless gets to offer an opinion because, well, they just really want him to be able to. And so the idea is that if somebody is in a unique position to be able to, to form an opinion that they can do that.
So in order to become a learned witness, like how much is there any sort of objective measurements or requirements that you can see whether, like this prison guard, did he have to have had a certain amount of experience with these psychotic patients, or is it just like his first day on the job? No problem. I'm a learned witness. Like
probably first day on the job, no problem would be fine. No, there's no objective standard. It's one of those discretionary with the court types of things. Do you think it's good enough? Do you think it's good enough? Yeah, Judge Gohl, surprisingly to nobody, thought that it was going to be good enough to have these prison guards who may not have even graduated from high school come in and testify as psychological experts about malingering, because we didn't call them that. We called them learned witnesses.
Okay, now these are the same prison guards that are also testifying about his admissions.
Yeah. Yes. That
okay,
they heard him say various things.
Okay, so there was no other inmates that testified that they heard confessions. These are all just the prison guards.
These are all just the prison guards.
Okay, and their testimony about his confessions are also the similar with inaccuracies or How did that?
I don't remember off the top of my head if he was testifying to inaccurate things to them, or he was, claiming inaccurate things to them, or if it was just more of the my recollection is that it was just more of the completely undetailed, I killed Abby and Libby. I think I killed them.
And this is all during that April month when he's absolutely psychotic. Everybody agrees about it.
April, May, June. Yes. Okay. Everybody agrees. He is psychotic.
Just 1 month.
So absolutely, by their own admission, during the month of April, and that is when most of this stuff is going on. But they continue to administer involuntary antipsychotics to him all the way up into June. So,
okay.
Do you go by what they say, or do you go by what they did?
Right. Okay. So let's move on to Dr. Walla, whatever the guy's name.
Dr. Walla. So Dr. Walla was the prison psychologist, and so when Richard Allen was first brought into prison, everybody goes through a kind of screening process, and he was identified as being psychologically vulnerable because he had a history of major depressive disorder. Now, that is supposed to mean that you're not supposed to be kept in solitary confinement for more than 30 days in Indiana, but they completely disregarded that policy when it came to Richard Allen and kept him there for 13 months. There was a whole lawsuit. There was a federal lawsuit involving that they had agreed to that standard. But anyway.
Wasn't that something also that I was talking about in the beginning of the show, which the judge referenced, that they gave notice? Was that included in their notice to the city or whatever it is, that they're going to be filing a civil lawsuit after the criminal case is over?
It might have been. It might have been to the Department of Corrections because
I think she said that's improper, that's incorrect, or you're not allowed to do that. Was there?
Yeah, and it's
yeah.
And it was one of these situations where he seemed to have a pretty rock solid claim that they already had this policy. They knew they had this policy. They deliberately violated this policy. This policy exists to protect people's Eighth Amendment rights. He's a pretrial detainee. He's not under the Eighth Amendment. He's under the due process. But so that might be a Solomon question about, does that mean it would be clearly established law in a 1983 context? But
Solomon.
but pretty clear that they had a real problem with their how they treated him in light of their own particular policies. But one aspect of that meant that because he was psychologically vulnerable, he was entitled to meet with the prison psychologist, and so he met with Dr. Walla pretty regularly throughout this entire course. And Dr. Walla is also, taking notes and observations and things like that. She is the source of what is the most quote unquote detailed confession from Richard Allen, which occurred, I believe, in mid-April, perhaps late April. Again, no question, he's floridly psychotic at this time, although she describes his demeanor at the time that he is supposedly making this confession as lucid and, intelligible and rational and so forth. But so she provides an account that she attributes to Richard Allen of going out to the bridge, seeing the girls, deciding he was going to, assault them in ways that I won't get your stream taken down for by being too explicit about. Used his gun, racked a bullet to intimidate them off of the bridge. Was in the process of trying to attack them when a white van came by and it scared him. So he forced them across the river to the ultimate, area where their bodies were found, killed them, and tried to cover their bodies with some sticks, and then left the scene. So that's the quote unquote detailed confession that Dr. Walla attributes to him. Now, the thing you got to know about Dr. Walla, a couple things you need to know about Dr. Walla, is that she is also real all over the place with her descriptions of Richard Allen and the condition that he's in at this time that don't seem to really line up with what is, number one, again, how they actually treated him. You are involuntarily injecting him with powerful antipsychotics. That tends to lead to the conclusion that you think he's not only psychotic, but so psychotic that he can't make his own rational decisions about whether he should receive medications or not. but also, the way that she describes him, he was lucid, he was cogent and stuff during like time frames where he is easy eating feces and things like that just don't seem to line up. But the more disturbing thing about Dr. Walla is that it turns out Dr. Walla is quite a true crime fan. And she had, in fact, consumed a massive amount of content about Richard Allen. She was listening to podcasts and things like that about the case while she was driving to and from work. She would post about it online. And ultimately, she ended up getting terminated from her position because there was a suspect that was being investigated at one point, who was this is Keegan Kline, who was also an inmate in Indiana Department of Corrections. He had been arrested subsequently and incarcerated. And so she used her position to look up records about Keegan Kline once his potential involvement in the case became known. And so, yeah, so that's
she was terminated. She was terminated before the trial.
Yes.
And was that allowed in as evidence?
Not the fact that she was terminated. No, it wasn't. They weren't allowed to ask that. They were allowed to elicit that she no longer worked with the Department of Corrections.
Can they say why?
No.
Wow. Okay. So that's Dr. Walla. So that's what the confessions entail. So you've got Dr. Walla, and do we know what she was listening to? Which podcast?
Well, so she's got some like the
question would be like, is this like listening to Andrea Burkhart or like prosecutors podcast? Like
both. She listened to pretty much everything. She listened to prosecutors podcast. She listened to Defense Diaries. She listened to Gray Hughes. She listened to she listened to Delphi After Dark, which was the local Rick Snay, one of the local guys. She listened to everything. She took a field trip to the Monon High Bridge to go there, like while she was treating Richard Allen.
And for some reason can you think like if you're listening so much about Richard Allen, was most of the podcast about how he's guilty, or was it the other way around? Why would she want to jump onto the train that everything that he's guilty and make up these confessions?
Mm-hmm. I mean, that's the $1 million question. The theory that I would offer behind that, you're always going to be kind of trying to mind read in a situation like this. So anybody's guess is kind of as good as anybody else's. But she would be the hero. She would be the hero of the story of Delphi if she's the one who was able to deliver a confession that, as it turns out, leads to him being convicted. And so she came up with this, detail only the killer would know, the white van. And so this was presented at trial as being, strong corroboration of the truth of what Richard Allen was saying, because there was a gentleman who lived on the far side of the Monon High Bridge named Brad Weber, and Brad Weber drove a white van. And so on the day of the murders, he had been at work and gave police different statements about his timeline, about when he did, in fact, drive home in his white van. But ultimately, claimed he drove home. This is what he testified to at trial, was that he had been at work. He got off work about 2:00, takes him about 20-30 minutes to drive home. And so he drove home in his white van, and the state argued this timeline fits, it corroborates what Richard Allen said. He's the only person that would have known that Brad Weber was there in a white van at the time. So it means he's telling the truth. So a couple problems.
The only evidence of the white van was this alleged confession to Dr. Walla, never ever brought up before.
Well, that's what they claim, but there's curiously, there are some mentions on one of these podcasts that Dr. Walla was known to listen to. Gray Hughes had brought up well before trial, and I think, in fact, before anything was known about Richard Allen's confessions as well, that Richard Allen was going to claim something about the white van. The white van was in discovery because the FBI had questioned Brad Weber early on in the investigation, early part of 2017, and so they had his different stories about the white van. They had video evidence from the neighbor who has, a security camera, and so can see the van driving by the road on its way home. So one of the problems with this theory is that that surveillance video, it doesn't fit the timeline. It's actually about 20 minutes after they claim that he would have been driving by his version. And the problem is that it's time stamped after the point in time where the prosecutor is alleging the girls are already dead at this point. They're timing this based on Libby's cell phone stops moving. They go through and they got the health data and stuff like that.
Yeah, I've heard that before.
Cell phones. So we know that whole thing well. Her phone stopped moving at 2:30.
What about Pocket State?
About what?
Pocket State. Okay.
We didn't get pocket states. This might have been an older version of the iOS, because this was back in 2017. We did get steps though, which we can talk about, steps and stairs. But anyway, so her phone stops moving at 2:31, and according to the time, the surveillance video of him coming home, he's not coming home until like 2:45. And then the FBI also has his phone data, his phone location data, and his phone doesn't ping from his house until about 2:50. So the timeline doesn't actually fit with the evidence, but that was the detail that they relied on to.
Was that brought up in the trial also? Like the defense?
So that was not. And this is quite unfortunate in my opinion, because they have relied on that particular piece of evidence to argue oh my gosh, I'm spacing on my case law right now. Glossop and Napui, the cases that hold that a prosecutor can't knowingly elicit false evidence at trial. They have argued that the prosecutor basically presenting Brad Weber's version that he drove home at 2:20 is a Glossop or a Napui error, because they knew from this other evidence that doesn't work. So it's one of the issues that's presented on appeal. We'll see how it does. I tend to think it's probably better fits the framework of ineffective assistance of counsel, but that they wouldn't be able to raise until post-conviction. So we'll just have to see. So,
are there any other data evidence that was involved in this case? Let's say like searches, Google searches, his cell phone. Where's Richard Allen's cell phone this whole time? Was it on, off? Was he texting? Was he calling? All that good stuff. What about that?
So no evidence of Richard Allen's phone being present at the scene or anything like that was ever presented.
Was there any data on his phone at all? Like, where was it this whole time? Was it
so they did bring in some searches, some internet searches, and these were things like there were some searches for like horror movie recommendations around Halloween. There were searches for information about the killings after they had taken place, like when it's a big deal in the news and stuff like that. But nothing in terms of like planning, preparation. How do I conceal my involvement? Nothing along the Brian Walsh kind of line.
How did this dispose of a body?
Completely different universes. Yeah.
Wow. Okay. So
Now, an important thing to know too is that the prosecutors did have geofence data. They had gone and gotten a geofence warrant for the crime scene from like the afternoon, of when the girls first went missing up to the point when they were found, and that geofence data apparently places other phones in the area at times when maybe, you wouldn't expect them to be there, or it would be suspicious that they were there. But the defense also wasn't able to bring any of that out at trial because the prosecution moved pretrial in limine to exclude all of the geofence data on the grounds that, according to the prosecutor, it's unreliable. They had no hearing. They had no evidence. They didn't present any type of an expert. It's literally just the prosecutor asserting it's unreliable. And Judge Gohl said, it's unreliable, can't come in.
Wow. A lot of basis for appeal. So
Yeah.
I mean, so this was, I mean, so again, just to recap, and what I love doing, I like to recap. So just to recap everything, you've got a guy who's there's a unspent 40 caliber casing, which is only compared with a spent 40 caliber casing from Richard Allen's gun, which they didn't test on any other guns. So we have no idea what that would have looked like in other guns. We've got a confession from somebody during clearly a psychot when he was psychotic. You've got Dr. Walla, who is a true crime enthusiast, who's also, again, and none of this is recorded, obviously, right? I mean, the only recorded confession was him talking to his dad. Not talking to his dad. Talking to his wife. Talking to his wife after he spoke to his dad and saying that he's what he thinks he's going insane. That what he spoke.
So there's also a few other phone calls during that same time frame where he talks to his family, and he says the similar types of things multiple times. The one to his wife was the first time that he had said something like that.
Right, and then you have the learned witness decide those confessions that they heard. Other than that, then you've got what else do you have in terms of evidence that he actually did this? Other than
that, what they did was largely just try to cobble together things that they alleged corroborated his involvement. So they had some video evidence from this place called the Hoosier Harvest Store that was on one of the roads that they claimed that he drove to get to and from the crime scene. They pick out this very, spotty pixelated thing that they say is his car, and that you can specifically tell that it's his car because you can see the custom wheels that he had on his car, which... this was like Karen Reed. It was a bit of a gaslighting trial. We have our own eyes. We can see what it is that you're looking at, and just not.
And their dog bites.
This did not land with me. I did not have the magical eyes that the investigators in this case claim to have. But so that was part of it. They had these, eyewitnesses who claimed to see a man, on the trail at the right time. And so, of course, the implication was that it was Richard Allen, but nobody actually asked him in court, can you identify the guy sitting right here at the defense table as the man that you saw on the trail? So not a single person ever identified Richard Allen. They had prepared composite sketches of the individuals that they claim to have seen, early on in the investigation. So these two sketches, according to the prosecutor's theory, are the same person, but they don't look anything alike. They look dramatically different. One of them, Betsy Blair, describes a man who is young, probably in his 20s. He's beautiful, tall, has this big poofy hair. And then the other woman, Sarah Carbaugh, describes this muddy, bloody man who's walking down the road at about 4 p.m. after the murders had taken place. He's wearing the cap, like bridge guy's cap. And he's just like an older, sort of bland looking guy. So they don't look anything alike at all. And neither of them really look like Richard Allen. I mean, the Sarah Carbaugh sketch, the muddy, bloody guy, looks, I guess, a little bit more like him. But neither of them really looks like him. They weren't allowed to bring the sketches in a trial, of course, because they would tend to suggest that the person that the women saw was not, in fact, Richard Allen. So the defense wasn't allowed to bring those in.
How can they not come in? I mean, how is that not part of the investigation? How can that not come in?
Well, she said they were hearsay.
I mean, it's part of the investigation, though. I mean, like it's not being brought in for the truth of the matter asserted, but it's brought in for as part of what the police are doing in the course of their investigation.
I mean, that is definitely an argument for bringing it in. Another argument, this is another issue that's come up on appeal, is not being allowed to use these sketches. Another argument that the appellate attorneys made was that this is an adoptive admission by the state that this is the person that they were looking for, that this person is the same person, and so to not be able to point that out is ultimately like deceiving the jury about the validity of that claim.
Wow. I mean, I remember being surprised by Judge Cannoni when she rubber stamped the defense's experts and made Dr. Marie Russell go through a 2-day Daubert hearing. And I was like, hey, how does that make any sense? But I'm sensing that we have a perhaps a similar issue here with this judge.
Bev is one of the best judges in the country compared to Gohl. I mean, I do not exaggerate like how they're not in the same ballpark. Gohl was almost sadistic in her treatment of the defense team, her treatment of Mr. Allen, and her treatment of the public and the press that were there to cover the trial. She achieved levels of evil that Judge Bev could only dream of.
Wow. I mean, and is there any mention at all of even slightly in the appeal about the judge's determinations and manner and demeanor?
No, there's nothing that goes to overtly anyway that goes to bias and stuff like that. And a lot of that is because, I mean, as you know, you read a dry transcript, you don't get the flavor. You have to be there present in court to hear the way that she would snap at the public, at the parties.
Why don't you give us a little flavor of that? Yeah.
Oh, there was during jury selection at the end of it. One day they had concluded, they're having some kind of, concluding discussion about logistics. And so some of the members of the press were starting to get up to leave the courtroom. And Judge Gohl snapped out at the public, sit down, just like yelling at you like you're a bad dog or something like that. And so I remember, I mean, I'm taken aback at this non-judicial deportment. But what caught my attention was that I saw Brad Rosie just freeze. I mean, you want to talk about like what a whipped dog does when they get that, they've been walking on eggshells around this person for so long that they're like afraid. He thought she was talking to him, and that he was going to be targeted. You could see how this had played out. So,
well, tell us about the interactions between the lawyers and the judge, because that's what I foresaw happening, that there's going to be a lot of that friction or tension, between the judge and the lawyers. Did you see any of that?
Well, so you definitely saw it from what you looked at, right? The removal of counsel, the ambush hearing, the threats to intimidate them. That ultimately culminated in the prosecution after the case got sent back down by the Supreme Court. And they said the attorneys get to stay on because you didn't follow the process for contempt. So what happens? The prosecutor starts a contempt proceeding. And so, we're in the final months of getting ready for trial here. And these attorneys have to be distracted, focusing on how do I defend myself against a contempt charge while I'm trying to get ready for trial. So they had long hearings about that. Ultimately, it was concluded that they did not act willful, but she wrote this just berating, derogatory opinion about how negligent and careless and terrible these lawyers were. She would just be very dismissive. She would be.
Was that also in front of the jury when she would act this way towards the defense counsel?
So not so much in front of the jury, except to the extent of how she would handle the objections and arguments and stuff like that. They did most of that at sidebar. They were very pretty good about not having speaking objections and doing those types of arguments in front of the jury. It was quite evident to me, as a lawyer watching all this unfold, just what different treatment there was of the defense team and their objections versus the prosecuting attorneys. But often, yes, her demeanor would just be contemptuous, just dripping with disdain for the fact that these defense counsel dared to say words in her court.
Wow. I mean, yeah, that's a big problem. I mean, it's really a problem that there was no cameras in the courtroom, so more people couldn't report this and see, and that's at least with the Karen Reed case. It wasn't just you, and I think there was lawyer Lee in there also, and I think that's kind of it. I think
Bob Motta. Yeah, we were the three lawyers.
Who? You and
Bob Motta, Defense Diaries.
Oh, Bob Motta was there also. Okay, fine. Yeah,
Yeah.
great. I mean, yeah, it's just the rest of us were not able to get in on this, and I'm telling you, I'm hearing this for the first time from you, and I'm just I'm hitting the back of my seat, like I'm just this is, and now
Martin, there were protesters that started to show up about maybe midway through the trial. And they would be outside, they would have signs and stuff like that. One of the very first signs that I saw said, "No cameras, no wonder." And that just it summarized so perfectly. Like, yes, no wonder. There is a reason. And this goes back to what I said at the very outset of this show. Look at who wants you to be able to see what happened, and look at who is trying to hide anything and everything from being able to be inspected and judged and criticized. And it tells you really everything you need to know about this case.
Yeah, I mean, I guess, it comes down to, I guess I would have liked to hear the closing arguments of both sides, because, I understand the evidentiary battles, and especially as a defense attorney, not able to argue as much. Even so, the evidence is still so suspect. It's so flimsy, the way that you described it for me, and I'm taking your word for it. Like it's the jury came back with the guilty verdict. So were they really basing it based on this .40 caliber unspent round and this confession by Dr. Walla? That's what it seems like that they did. And it seems like there's a lot of argument the other way that could have been made, and maybe was made, but that's why I'd like to see the closing arguments. What do you think about the attorneys doing the best with the best with whatever evidence came out during the trial? Do you think they did a good job, and just the hand behind their back?
Yeah, I mean, I think this wasn't just one hand. This was both hands, tying behind their backs in terms of being able to present a defense. And I mean, we've only touched on what they weren't allowed to go into. We haven't even talked about third-party suspects, problems with the crime scene, and stuff like that. So their ability to be able to offer a meaningful counter explanation to the state's version of events was basically non-existent. And that, for me as a trial lawyer, that's at the heart of what I'm trying to do in a closing argument, is because I'm pointing out to the jury, reasonable doubt is based on there being reasonable alternative explanations for this series of evidence. If the prosecutor's explanation for why this evidence is what it is the only possible interpretation, then yeah, you have proof beyond a reasonable doubt. But if it can mean other things, then that means you have doubt about the significance of what this evidence means. And so here, let me provide you with some examples of what some of this other evidence could mean. They weren't able to do that on very fundamental things like, why does the crime scene look the way that it does? Did law enforcement look at any other suspects? Were there any other people that came under suspicion? And what was the weight of the suspicion against those people? All the problems we've already talked about with the things that they weren't allowed to get into in terms of like geofence warrants and problems with ballistics and stuff like that. So,
give me a flavor for the third party.
Oh my gosh. I mean, which ones? There's multiple. So if part of the evidence, like part of the strong argument for Richard Allen being guilty is that he confessed, there's at least two other people that also confessed. So one of those is a guy named Elvis Fields. Elvis Fields is related to what is kind of the Odinist theory of the commission of the crimes. So this is based on early in the investigation. The FBI brought in some behavioral analysis unit experts to look at this crime scene, because the crime scene is weird. You have the girls have been posed after death. That's not in dispute. They were put in certain positions after death. There are some sticks that are placed on their bodies in kind of these specific formats. There's a puddle of blood that also has sticks on it in a particular configuration. There is a tree that has a mark on it made out of blood. And then just the manner in which the girls were killed. Their throats were cut. They were exsanguinated. There is evidence that the blood flowed over their chins. So meaning they were in an inverted position at least some point in time. One of the girls is nude. The other girl is dressed in the first girl's clothing. So it's a bit of a peculiar crime scene. So the FBI, from the outset of the investigation, says this has hallmarks of a ritualistic killing.
You better believe it.
Yeah, and so they consulted with a number of different experts who looked at, for example, these stick formations and said, "Oh, these look like what somebody who is trying to depict Norse runes would do. These look like certain types of Norse runes." And so
what's Norse runes? I'm sorry.
So Norse, meaning Nordic, and the old system of writing was a runic system of writing.
Okay.
And so there are primarily among, at least in the US, among white supremacist types of groups, which I'm not sure if you know that Indiana is still the home of the Nazis, the American Nazi Party. Yeah, there's some weird stuff that goes on in the woods there. Love you, my Hoosiers, but you got some weird shit going on in your state. So anyway, in the U.S., it's mostly associated with white supremacist types of groups, but they have these what they call Odinist practices, and it's this pseudo pagan religion where they are looking at the Norse gods and Odin, and they're doing these blood rituals and things like that normally involve things like sacrificing animals, bloodletting chickens and goats and things like that. But doing it in these ritualistic types of way and associated with runes and stuff like that. So you have a lot of these investigators from the state early on in the process going down this road of investigating, is there an Odinist link to this? Well, lo and behold, there is this guy named Brad Holder who is an Odinist in the area. He has a friend named Patrick Westfall who is an Odinist priest who lives in Delphi. And Brad Holder's son, Logan Holder, is Abby's boyfriend. Abby had, in fact, texted Logan Holder. We only just learned this on appeal. She had texted Logan Holder the day that they were killed, telling him they were going to be going out to the trails and asking if he would meet them there. He had to be in school, so apparently he declined to do that. So they have, an Odinist with an actual link to the girls and an apparent, means by which they would know where and when to find them. This is also the timing of the crime. It took place on an Odinist holiday. The night between the 13th and the 14th was a big Odinist holiday. And of course, like we said, the crime scene bears these rather peculiar trademarks that, according to the state, were just, they just tried to conceal.
It was just a coincidence.
He's trying to conceal the bodies, but there's no concealment taking place at all.
It's a coincidence, like some butt dials at 2 a.m.
Yeah. So apparently there was investigation of these individuals early on. Brad Holder and Patrick Westfall. They both claimed to have alibis. Patrick Westfall said, "I was with my kid." They said okay and did no follow up on that and cleared Patrick Westfall. Brad Holder said, "I was at work," and so they went and talked to his work, and they got his record from clocking out from work at 2 something in the afternoon, 2:30 in the afternoon. So okay, couldn't have been him. Now the clerk at the work pointed out he wasn't actually even working that shift. He was working the earlier shift. Like if he had worked his actual shift, he would have gotten off at 1:30 or 1 o'clock. But his badge checked out at a later time. The badges are up on a wall, right? So anybody can get them, and it would not acknowledge anybody. You could clock in and out for somebody else, and there would be no way for them to verify that, except that they do have cameras. They have security cameras, on the job site. Offered the law enforcement to be able to go and check the cameras to see if they could verify Brad Holder's time of leaving, and they said no thanks, and they cleared Brad Holder.
No, they didn't even look at the surveillance.
No,
Was
No.
this allowed to be brought up in trial? Tell me no. Of
No,
course not.
no, none of the third party stuff was allowed to be brought in. So I got into the holders.
But even on the lack of the investigation here, forget about the third party culprit, but the fact that they didn't even look at the videos, that that's like a separate defense as opposed to like a third party culprit. You didn't do your.
I agree. Of course, it is. But she lumped it all into the same. This is the third party culprit. It doesn't meet the standard. In Indiana requires a nexus between the individual third party and the crime itself.
Yeah, well,
I look at this and I'm like, they have more evidence of his involvement than they do of Richard Allen's. I don't know how you don't have a nexus, but she just kept saying over and over again, "There's no nexus. There's no nexus." At one point, the defense even asked, like, "What is a nexus?" Because I don't know how we're not going to get there. And she said, "Well, for example, DNA." And we're like, "Yeah, no kidding. Maybe DNA would be a good nexus."
And there's no DNA from Richard Allen. It's unbelievable.
I got into Brad Holder and Patrick Westphal by way of Elvis Fields, because Elvis Fields was this guy who kind of like flirted with interest in Odinism, and as far as from what I was able to tell, they were never able to like firmly establish a relationship between Elvis Fields and Brad Holder and Patrick Westphal, except that Elvis Fields followed Brad Holder on Facebook and copied him, like did all these things that Brad Holder did. But Elvis Fields had confessed to twice. He had two sisters. He confessed to both of them, told them that he had like joined a gang. And I don't honestly, like the specific details of what he said at this point. I don't even necessarily remember, but he confessed to his sisters. They passed polygraphs. I mean, that doesn't mean anything to me, but just for whatever that's worth in investigative terms, you would think should have been significant. So they followed up with Elvis Fields about, does he have an alibi? He claims that he was at the hospital visiting a sick friend. And when they asked to be able to check his phone to verify his location, he then came up with the explanation that it wouldn't show him there because hospitals block the cell signals when you're there. Did you know that? I was unaware of this, but according to Elvis Fields, you would never be able to get his cell signal. And the police said, "Great, we're done with that." Oh, I remember one of the other things that he said when they interviewed him. He made a comment that if his spit were found on one of the girls, but he was able to explain it, would he still be in trouble?
Oh my gosh.
Yeah. So
wow.
That's one independent confession. That's Elvis Fields. Collateral to that, Brad Holder also had his ex-wife. She testified that he had told her that Patrick Westphal did the killing, and that they'd had a falling out after that because Patrick Westphal had wanted to like up the ante with his sacrifices, his rituals. And they had a difference of opinion about that and had a falling out. But she claimed that Brad Holder told her, that Patrick Westphal had done it. So that's one set of third-party suspects with some confessions. The other one you have is Ron Logan. Ron Logan owned the property where the bodies were found. He was one of the most common tipster when tips would call in like that. I think that guy's Bridge Guy. That guy really looks like Bridge Guy. It's Ron Logan. Tons of people thought Ron Logan was Bridge Guy. He offered, so because he lived on the ground, they had the investigators had contact with him very early on. He was offering alibis that were not true, that were false, before the girls were ever even found. So before you even know that you need to have an alibi, he's offering an alibi that is not true, and they're able to go in and substantiate that it's not true. He owns one of the 40 caliber firearms that was compared to the unspent shell casing, the unspent bullet, and originally could not be excluded as.
Wait, hold on a second. So they searched his house?
Yes, they did.
Why would they search his house? Just because a dead body is on his property, they should search his house?
No, there is it mainly had to do with the fake alibi. He matched the description. He gave the fake alibi. It was a bust. And he also had he had like substantial criminal history. He was on probation at the time. I'm trying to remember if he was originally like they did a probation search and followed.
Well, I mean,
I don't remember. But he ended up going.
If he would have invited the girls onto his property, I'm sure his house would not have been searched then.
Yeah, exactly. I don't know.
I'm just making a reference to Karen Reed.
So he ended up ultimately being thrown back in prison for a probation violation. And while he was in prison, he allegedly confessed to a gentleman named Reese Davis. And so Reese Davis filed an affidavit describing this. The defense brought this up. And I mean, I should say the defense ultimately brought this up because this was originally concealed from the defense. It wasn't produced in discovery. They found out about it later. But Reese had been, his cellmate had been Ron Logan's cellmate. So yeah, you kind of question. I always question the jailhouse informant because there's too many personal interests involved. Yeah. But if you want to talk about details only the killer would know, the confession that Reese Davis attributes to Ron Logan has that because he talks about how the girls' throats had been cut, which was not a detail that was publicly known at that time. But even more specifically, he said that one of the girls had nicked an artery, and so she died faster. And this was absolutely the case. As to the girls, Libby had had her carotid artery cut. Abby had just had her jugular veins severed, and so they both die of exsanguination. But the process is much quicker when an artery is severed than the veins. So, yeah, that was Logan, the other third party suspect.
And all these people, they were not allowed to present as evidence.
None of this.
This is what else am I missing? I mean, like, it's unbelievable. This is just crazy. I mean, this isn't America.
Yeah, I know. No, this was the most banana republic lynch mob style trial I think I've ever seen. I've ever even imagined.
Wow. Yeah. I mean, okay. So, I mean, I guess we'll see. It sounds like he's going to have a really good shot in appeal. And then the only question is if he gets a new trial, is he going to have to be stuck with his judge again?
Yeah, well, and the only real hope we have for that is that she's up for re-election in 2026. So we're please, somebody in Fort Wayne, Indiana, please run against Judge Gold because she does not belong on the bench. I got to tell you, just from having sat through that process. So you followed the attorney removal as the same time that was going on. There was also some litigation happening over her hiding materials from the court docket. Did you follow any of that as well?
No. So this is the judge?
Yeah, this is the judge. So at the same time that the writ to get Richard Allen's defense counsel was going on, there was also this second writ that went up to the Indiana Supreme Court, and it dealt with the fact that there were all of these things that were just not being entered on the docket, like hundreds of things that were being hidden and not in compliance with the rules that Indiana has to make things confidential. And so the Supreme Court did issue an opinion on this, where they basically said it was moot because, again, Judge Gold just went back and she blamed the clerk. Okay. Blamed her clerk, threw her clerk under the bus. It was the clerk's fault. We're going to reinstate all these things. And so they did. So that was mooted, but they still included this language in their opinion, basically saying, here's the process, here's what the rules say you have to do. And we expect all courts to follow these rules. And so promptly, when the case is sent back to Judge Gold after they declined to remove her from the case, she went back to the same thing. She just continues to withhold documents without following the rules to be able to do that. So it's still an issue, and being corrected by the higher court has no effect. It's not changing her respect for the laws that she is bound to follow. She acts like a tyrant on the bench, like a monarch. It's a very imperial court style that she runs.
It's unbelievable. I mean, this is absolutely crazy. This is mind blowing. I mean, this is, if you thought Karen Reed was bad, this looks 100 times worse.
Yeah, this is horrifying. It's horrifying not just because the process is like turned up to 11, I mean, the unfairness on steroids, but the fact that it worked. He's in prison. He got convicted. He's in prison on this.
Yeah, I mean, this is unbelievable. And I have to ask you one other thing, because it seems like the chat wants you to talk about this. Is another fact that I don't know, if you have another minute.
Mm-hmm.
And that is, there's some sort of Google searches that were talked about on the stand. Some sort of...
Yeah, so this is what I was talking about before. With they had a little bit of internet search history, but it was so milquetoast as to be just kind of bizarre. Oh, they're talking. I see in the chat, Cecil. Okay.
Yeah. So what do we got?
Yeah, so we haven't talked about the phones, Libby's phone, and just the disaster that they made out of the forensics, the cell phone forensics in the case. They basically blew it from the outset. They destroyed data that would have been helpful because of how they handled the phone. And what they have now is like it's so problematic that it's not clear how reliable it is.
They destroyed data? The police destroyed data?
Yeah, police destroy data. So not this. There's no evidence really that they did this intentionally. What happened was when they first got the phone, it was like low battery, and so they turned it off and then had to turn it back on to extract it. And what happens when you do that is that affects some of the data that you're able to get later on, including, for example, the power on off log. There were some questions about the state of Libby's phone over the course of the evening, the afternoon and the evening between when they were killed and when they were found, where something like knowing if the phone had been powered off would have been very helpful, but they weren't able to do that. Another problem was that when they first got the phone, they did a limited extraction of it. They did what they call a physical extraction, which basically gives you all the user data. So, things that you would be able to find just by opening up your phone and looking through your photos, looking through your messages and stuff like that. It doesn't give you any of the underlying system data, which is what you get from a full system extraction. But the problem is that once you do the physical extraction, it's highly questionable how reliable later extractions are because of the effect on the data in the phone. So a lot of issues with the mishandling that from the outset. But anyway, so one of the things, like the one thing that the defense was allowed to bring in that was exculpatory, was they had their own cell phone expert who reviewed these extractions, and they found that there was evidence that at like 5 o'clock in the evening, somebody had inserted wired headphones into the phone, and that this took place like milliseconds after a call came in. So like the phone would have rung, and if you plugged in headphones, it would have silenced the ring of the phone. And then the headphones, the wired headphones, were removed from the phone at 10:30 or so that night. So this is there in one of the phone logs that registers actions being taken towards the phone. Now, this is entirely inconsistent with the state's theory, because the state's theory is Richard Allen killed the girls at 2:30. He, did whatever he, they say he needed to do to conceal and whatever. No real explanation for why the crime scene was the way it was. But then left at 4 o'clock in the afternoon, is seen by Sarah Carbaugh walking muddy and bloody down the highway, and never goes back to the crime scene. So any involvement with the phone at all after maybe 4 o'clock in the afternoon is going to be completely inconsistent with their theory.
Unless somebody was walking by and picked it up.
I mean, possible, but then who and where, and like who's doing what with this phone? That person would be a witness. How do we identify them? That type of thing. So what ends up happening is that the defense expert testifies to this during trial, and then the state gets their rebuttal case. So they go in and they call in their cell phone expert, who is this officer Cecil. I think he's a trooper, who had done like a lot of the cell phone forensic work for the state. And he testified that when he heard that the defense was claiming this during their testimony, he went out into the hall and he Googled whether there was some other explanation for how why the phone would register this type of data. And he found some type of user forum on Apple where they said that sometimes dirt or water getting in the headphone jack can make it act like it has headphones in it.
Don't tell me
And
that.
so,
How can this come into? Stop. I'm done. There's no way that this is coming into evidence.
It absolutely came into evidence. Yes, this is a classic hearsay problem, Martin. This is such hearsay that I've told people I've literally won an appeal on this issue about police officers just kind of Googling random things and then trying to use it as evidence.
Oh my gosh.
Literally won a case on that because it's so obviously hearsay. But no, they Judge Gold let that come in over their objection. And so that was how they were able to mitigate that rather damaging piece of information from the defense through Cecil's Google search.
Wow. I mean, it sounds like the more I dig on this case, the more I'm going to be just shocked and shock and horror.
Yeah.
I mean, it's just, and this is going on right in the heart of America.
Right in the heart of America.
It's really terrifying. Yep. Wow. Okay.
Yeah.
Well, I mean, I appreciate that you sent me all those documents or the access to them. In case I got some homework to do now. I mean, on this case, but I mean, people got to hear about this. I mean, people have to hear about this.
Yeah.
Don't you think so? I mean, like, it just seems like it's because there's no cameras and because a lot of us were not able to see what's going on. And I've told my channel, like, I don't like to just trust the reporting that's going on in the court. I want to see it myself. You know, you're obviously on a higher pedestal than everybody else, but it's always difficult to tell everyone this is what's going on when you're just getting it from the news reports.
Well, and that's the whole problem, Martin. That's been the issue with this case. Like, I didn't really follow Delphi closely until the time of trial because they made it so difficult to be able to get access to stuff. And and I know that trying to rely on journalists to report about court filings and what's happening in court and stuff like that, it can just be a little bit of a frustrating task because it's just often not correct, or it's not telling you the information that you as a lawyer need to know to make sense out of it. So it was so difficult to get access to legitimate, good information about the case it's very hard to have any kind of opinion about it without having that firsthand view. And so that's one of the main reasons why I went to Delphi in the first place, is because I knew we're not going to get video cameras. We're not going to be able to see this for ourselves. There's been so much that they've kept undercover. There's a lot of sus stuff going on with the third party suspects and stuff that the defense isn't being able to allow, isn't going to be allowed to get into. So many problems with it procedurally. If I'm going to have an opinion about this, I'm going to have to go and see it for myself, because that's just going to be the only way to get good information about it. I think that was a feature and not a bug of this particular handling of the case. That was the entire point. They didn't want us to see, and that's why they made it so difficult to be able to get the information.
And it seems like they're still hiding stuff.
Yes, absolutely.
So did you? How long was this trial, by the way?
This trial was 5 weeks.
5 weeks. So did you? I mean, you're not close to Indiana, are you? You're like in.
I am quite a ways from
right?
Indiana. So yeah, I went and had my Airbnb out in Logansport, Indiana. I stayed there for 5 weeks. Yep.
Wow. Okay. Well, that's dedication. But I mean, it's you're doing the right thing, especially on this case. You're shining the light onto some real problems with the process and with everything. Here's another thing. Ask her about the deleted interviews and the hair in Abby's fingers. Keep digging. She has scratched the surface for you. I mean, I don't know how much time you want to give me, but like this is so unbelievably shocking. Maybe we'll do another.
It goes on and on and on. It really does. I mean, like I'm not exaggerating when I say that every single step of this case, from the very beginning all the way through, to today, is tainted. It's mishandled, or it's misdirected, or there's dishonesty. I haven't even talked about the lies that law enforcement, other than just the very beginning when we talked about the search warrant, the lies from law enforcement about this case are just, they should be shocking. They should be so disturbing because of how easy and cavalier that they were about lying under oath to the people, to the court, and nobody seemed to take any of that seriously.
Wow. I mean, he's going to have to get a new trial. And
I hope so.
It better be with a new judge also. I mean, this is ridiculous. This is absolutely nuts. I mean, again, and I'm taking your word on this, obviously, but I'm going to have to do my homework on this And do they have at least the transcripts? Have they been released that we're able to, at least read the transcripts?
So the transcripts are out. You can get the transcripts on the All Eyes GitHub. All of that is there. A limited amount of the trial exhibits are also available. Pretty much everything that's publicly available you can find on that website. So things like, yes, the interrogation videos. I would encourage you to watch those. There's 2 interrogations. There's the first one with Mullen, Officer Mullen is his name, where it's the one where he's kind of starts to come under suspicion, and he realizes, but he's been very forthcoming, and they distort everything that he said, to be able to get the subsequent search warrant. Then there's a second one with Jerry Holman, after they do the search of his home and they find the bullet. And they confront him, with this, and they lie to him, overtly, because it's Reed technique, and you get to do that. Police get to lie to the suspect to try to trip him up and get him to their own reality and stuff. But he didn't fall for that either. He handled himself, I thought, quite well during both of these interrogations. I would love to just see you watch them and have your perspective on what do you think? How do you think he comes off?
Yeah. We need something to do, by the way, and I know we have some great people to do this, like the trial channel. Maybe take all those transcripts and turn it into like an AI version of voices, so we can, watch the trial or listen to the trial instead of having to read 5 weeks of trial transcript.
So if you go on to Criminality is the website, she and Sleuthy Goosey have been rereading quite a bit of the transcript. So there is a fair amount of that is out there.
Oh, okay, fine. Great. I mean, because I think we have to get more eyes on this case, because I mean, what you're describing is horrific.
Yeah.
It's terrible.
It is. It's the most horrifying case by far that I have ever seen in the American criminal justice system. It so far exceeded what I was expecting when I first went there. I mean, I thought it would be kind of bad, but just within the framework of what a relatively jaded black-pilled defense attorney expects to be, kind of bad, which is, systematic unfairness and maybe a little bit of dishonesty around the edges and stuff like that. But this was just so overwhelmingly shocking on pretty much every single level. I wondered if I was in a third world country.
Yeah. I mean, what you're describing certainly sounds like it. I think my ancestors would have some good experiences with it, but I mean, like, that's what it sounds like. It's just crazy, and this is going on now in 2025. Well, anyway, you've been with me for over 2 hours now, and I mean, I can't tell you how much I appreciate our conversations. I love talking to you about anything, and this is obviously something I knew very little about, and I hope again that we'll have you on again, and we'll continue talking about this case or other case. But just thank you so much for coming on again.
Yeah, always a pleasure. And anytime you want to follow up, you want to watch any of this stuff, read any of it, we'll chat about it. I would be happy to do it anytime. Okay, sounds so good. Thank you very much. All right, everybody. Well, thank you very, very much for tuning in for that. I mean, this is absolutely, there's just no words to describe this. I mean, I'm just blown off my seat. I'm literally blown off my seat. I can't believe everything that she's been saying. It's almost like this has to be a fiction. Like, are you actually telling me the facts of what happened in this case? And it seems like it is. It's just unbelievable. I mean, I'm just absolutely shocked. I mean, we thought Karen Reed was bad, and this was not. It's not even the same ballpark. It's not even in the same ballpark. I mean, it sounds like it's absolutely nuts. Third world country stuff. So I have to get over my initial shock in order to actually look into this more. But I had very little idea about all this stuff. I had very little idea, because I was just, Richard Allen, the case in Delphi. I wonder what the evidence is. I wanted this. Okay, I'm not going to see the video. I'd be able to see the trial. Okay, so I don't know. Okay, I just won't concentrate on it so much. And then I've been, I follow Andrea and I see different things that she's posting, whatever. But I'm like, okay, maybe there's some more to look into by Richard Allen. Maybe there's some more arguments. Maybe there's some more things that are going on over there that we don't know. And anytime someone's asked me about it, the answer has always been the same. Yeah, I'm hearing from Andrea. I'm hearing from that maybe there's some oddities or some weird things going on in that case. And now actually talking to Andrea was just mind blowing. I'm like, wow, if this is what's really going on, and this would happen with Richard Allen, I mean, he's absolutely getting the dirty end of the stick. It's completely unfair. So yeah, I mean, that's all right. Well, I mean, we need some more eyes on this case. What can I say? That's what we're here for. We're here to talk about this. And if there's something that's
that's improper and correct, or a judge acting a certain way, then we got to highlight it and let everybody know. And, this is not the way it's supposed to operate here. So thank you all for joining. If you get a chance before you leave today, make sure to hit the subscribe button, hit the like button, and we will see you at the next video. Have a great Sunday. Thanks for joining once again.